Hello, and welcome to this Commonwealth Club World Affairs program. My name is Senator Elizabeth Warren, and I am truly delighted to be moderating today's program. It's my pleasure to introduce Melissa Jacoby. She is the Graham Keenan Professor of Law at the University of North Carolina at Chapel Hill, and she is the author of an amazing new book called Unjust Debts: How Our Bankruptcy System Makes America More Unequal. Now, Melissa is a leading expert on debt, lending, commercial, and bankruptcy law. She's testified before Congress, and in 2021, the Chief Justice of the United States, John Roberts, appointed her to help design educational programming for the nation's bankruptcy courts. Some years back, she was also my student in bankruptcy law class. And so now it is a tremendous pleasure to be in conversation with her and with all of you about this groundbreaking book. I want to remind our audience that if you have questions for Melissa, please submit them in the YouTube chat, and we're going to get to them later in the program. Melissa, let me start by saying welcome. And if it's okay with you, how about if we just start off with some questions?
I would expect nothing less.
Nothing
Thank
less.
you for
That's
being
how
in
class always
conversation
went.
with me.
Good, good. So let's start by kind of setting the table. We may have some bankruptcy experts who've tuned in, but we may also have people who are not bankruptcy experts who've tuned in. So how about if we start big picture? What is the point of bankruptcy, and how is it supposed to work? If we're all perfect, how's it supposed to work?
Bankruptcy is a superpower. It is to cancel debt. Debt relief is its core. It's even in the Constitution.
Mhm.
And if the system were working properly, it would provide debt relief, particularly for individuals and families, help small businesses get back on their feet. It's a powerful law, however, and powerful laws get in the hands of lots of people who have creative ideas of how to use them.
Right.
So things have gone a little awry, ultimately because, like so many other things, this looks like it's about money and debt and narrow things, but really it's about power.
Okay. All right. So let's disaggregate that just a tiny little bit. So we have bankruptcy laws for individuals, people who get into financial trouble. Why do we have them? Why don't we say pay your debts? That's it. We're done.
Well, Netflix showed a TV show about that called Squid Game.
Mm-hmm.
And basically, what we saw there was it's not good for anyone to have people in such financial distress that they have nowhere to turn but playing games to the death.
Okay.
So, our society puts a lot of risk on families, including risks that have no relation to their own decision making. We need them to be able to get back on their feet, participate in the economy. Economists think bankruptcy is a good idea. So it makes everyone better off to provide debt relief in
Okay.
this economy and society.
So a lot of ways that you can go broke in America today. You can have a bad medical diagnosis and get hit with bills. You can lose your job, not have an income coming in. You can take on debt to go to school. You can be in an accident and be responsible for a lot of different things can happen. You run up your credit card bills, just be irresponsible. A lot of things can happen. The idea is if it gets so overwhelming, you go to bankruptcy, and bankruptcy is a place to be able to resolve this. Now, individuals are not the only ones who can file for bankruptcy. There's also an idea behind companies, businesses going bankrupt. Can you say a word about what the idea is there? It's obviously, we're not worried about them getting back on their feet to be able to support themselves. There must be a different rationale here.
Well, that's why I call corporations fake people in the book, just to try to make it clear. I don't mean it as a pejorative term, but we
Except
have,
maybe a little. Go ahead.
well, I, it's natural. We're going to give some rights to corporations in America. There are some good things about doing that, but then that's the building block for small business, big business, nonprofit, and even municipalities. In those situations, we're really looking instrumentally. Everybody is better off if this company stays in business. It keeps people employed. It keeps relationships with with suppliers. It promotes competition between companies and the ability to continue to make money, and everyone is better off with the company. It's worth more alive than dead in those situations, and everyone is supposed to benefit from that.
Okay. So you describe throughout this book, you kind of keep a two-party narrative going here, and it makes it a really interesting read. You say we have this one system that is about going broke, but there are a lot of different ways to go broke. One is how live human beings go broke and what kind of help they need so they can get back on their feet. And the other is businesses that go broke, again, for a whole variety of reasons. You know, the world changed around them, they did stupid things, they got hit by just unfortunate circumstances and hurricanes, and the insurance lapsed, and, you know, on and on and on. But often it makes sense to give them one way to deal with their debts so they can continue to employ people and keep them going. All right, so we've got these two systems that we talk about, somewhat different rationales for why we have bankruptcy system to deal with it. But let's go to the central argument of your book, because you say that what's going on now in the bankruptcy system is that first, the bankruptcy system has fallen way short of providing basic debt relief for struggling families. That was part one. And second, that lawyers and powerful companies have figured out how to use the business bankruptcy portions in order to transform our legal system, I love the phrase you used, into a legal Swiss Army knife, which I think is a really terrific term for describing this. So let's start with the business end of this. I think this one's going to be an interesting one to work with. What does this Swiss Army knife look like in action in our bankruptcy system?
Well, let's start with the rule of law. Congress wrote a handbook for how bankruptcy is supposed to go. And for years, creative lawyers like to solve problems. And I think there's often a well-intentioned germ here. Say, well, we could accomplish really important things if we just veer a little off the handbook and go with the vibes of what the bankruptcy law was supposed to do. So Unjust Acts talks about two paths to that. The one I most talk about as a Swiss Army knife is the use of bankruptcy by companies, especially that are otherwise doing fairly well, that only want to deal with allegations of wrongdoing regarding individuals who have been harmed in large numbers. And while there is a rationale for that use, it wasn't what Congress intended. And so what started as trying to make the best of a bad situation has pushed further and further to undermine the rule of law, to not deliver the financial promises to injured people, and also to leave individuals with the sense that this system simply is not fair to them. No one is listening to them. They feel unheard. So those are some of the concerns that I have about the mass tort route.
Well, let's put some meat on the bone for everybody, like I said, who's not intimately familiar with what's going on right now in the bankruptcy system. And that is, you got a business, big business, it's doing a bunch of stuff out there. It's got a lot of divisions, hires a lot of people, it borrows money, it pays its money back. It's actually doing just fine. But it did a really terrible, horrible, lousy thing. It poisoned a bunch of people with asbestos. It put out breast implants that caused terrible trouble. Oh, I know. It manufactured opioids that ended up addicting and killing people all across this country. Terrible, terrible things that these companies do. And so you say your problem when you're talking about Swiss Army knife is not the companies that get into trouble on the basic business stuff, that borrowed too much more money or put in a factory in a place that turned out to be a stupid place to have a factory. No, you say the problem is when they try to use bankruptcy to solve this huge liability they've got for having injured a whole bunch of people. And just obviously the examples I picked are all real examples where bankruptcy was used to deal with mesothelioma coming from asbestos, where it was used to deal with breast implants, and then of course most recently where it's been used to deal with the opioid epidemic. And when I say it, I say deal with the problem. It's not deal with the problem, it's deal with people who've been injured who want a chance to go to court, frankly, and sue the companies to get heard. What's the problem with bankruptcy resolving those claims against the company the same way it would, some bank that lent them money, or some buyer of goods that turned out they didn't like the goods and they want their money back?
When bankruptcy is used to resolve problems with counterparties like lenders, banks, other parties who are accustomed to the idea that you have a contract, but there's an invisible ink in every contract that says, unless the party goes bankrupt.
Yeah, yeah,
And they know
it's
that they
true.
can rewrite
Mhm.
that contract in bankruptcy. So they're going to start with what's written. They might have some disagreements about what's owed, but they're going to be negotiating about the interest rate, the payout schedule, other tangible things. And then the majority can bind the minority, which means that one big thing about bankruptcy is that I might not get what I want as a creditor at the end. The business might continue if enough other creditors go along. These rules technically do apply to people who are injured. Congress did say that the definition of debt and claim is so broad. It includes things related to climate change and employment discrimination and lots of other stuff that we're really worried about in this country and around the world. But as applied, these claimants, these individual claimants, are not getting the full treatment and protective treatment that bankruptcy law on the books is supposed to provide, because it's really hard to do that with a lot of people who don't have a value. They haven't had their day in court. We don't know the liability. We don't know the magnitude. And they're really just being treated as one big lump when they're individuals with very different levels of severity of injury. So
Okay,
I worry a lot about these cases of people with severe claims and people with less severe claims, and how one might rule out the other.
okay, so there's one group you put together, or one problem with the bankruptcy system as it exists right now. You say for personal injury, it's really different from commercial lending, for example. And you say, I kind of get how commercial lending, and you hit on it lightly, but I want to make sure everybody pays attention. One of the superpowers of bankruptcy is you can bind the dissenter. So, you got 100 creditors, and 96 of them say, that's the best we can do. We'll take 80 cents on the dollar, we're good, let's go, keep this business alive. And 4 or 3 or 2 or 1 can stand up and say, not me. And of course, the risk is the debtor will say, okay, I'll give you 100 cents on the dollar. And then of course the whole deal comes unraveled and the business fails. So bankruptcy's superpower is to say in the commercial setting, we're going to even bind the minority. We're going to bind the group that didn't want to go along, or even the one individual who didn't want to go along. But then you said you move that over to people who've been injured, lots of people. And some people breathed asbestos dust and got a little sick, and some got a lot sick, and some died of horribly painful injury. Some were just the spouses of people who brought asbestos dust home in their clothes, or even the children who breathe that stuff. And you say, what bankruptcy has done is it said, nope, not going to court. We're all just going to assess what those are worth. And you're worried that a lot of different things all get lumped into the same, ground up, and say, oh, it's all just applesauce. And the answer is, not if you got hurt. And our court system assumes individualized justice. Our bankruptcy system says, no, we're going to mash it across everyone. Is that a fair description of what you're saying?
It is fair. And what I hear back from restructuring professionals, which are lawyers who do bankruptcy cases, that's just the
Mhm.
fancy word for it, is that, well, we work out those differences once the bankruptcy is over. We have a elaborate process of evaluating the claims and say who has a more severe claim and who has a less severe claim. My argument is that's too late. That bankruptcy was written to give people who have a more severe injury a bigger voice in the negotiation and to have more leverage in deciding the future of the company and what even that compensation structure will look like. There's
Mhm.
also another point here that often gets lost. Although the majority of the Supreme Court in the Purdue Pharma case last
Which we're going to
week
come
in
to in
this,
a minute. Mhm.
yes, seemed to get it. When we talk about binding dissenters, it is a really powerful part of the bankruptcy system. We have to remember that lots of people don't vote. And when we're talking about people in the opioid cases, when we're talking about child sex abuse cases of traumatized people, there are a lot of reasons they're not voting. It could be they are incarcerated and did not get the notice. It could be the noticing strategy didn't work for
Yeah.
them in terms of getting them the information. It could be that the documents are impossible to understand for anyone who even working in this area, it seems to me. And too often they're ignored. They are ignored in the law in terms of counting the majority and the dissenters. But when you hear in the press that 97% of families devastated by the opioid crisis voted in favor of this plan, it's not true. It's 97% of those who voted. More people
Mm.
didn't vote than voted in favor combined with those who voted against. And again, there are good reasons for that. So I think there needs to be more attention to their needs during the bankruptcy case, and if that shifts how much time is spent, then so be it, but it has to be done.
Okay, so that's one part of the problem. Since you're on it, let's go to the Sackler part of the problem as the kind of the best example of this. And you wrote a terrific New York Times op-ed on this. Think about in the Sackler case, the problem there is not just how many people themselves became addicted, struggled with it, the health implications of it, the family implications, but people died. And how many people lost sons and daughters, brothers, sisters, moms, dads, friends. Um, and the but in the Sackler case, there is an additional real Swiss Army knife action going on here. You want to explain that a bit more?
For decades, we have seen the creep of this movement, and I wish the Supreme Court had spoken, I don't know, 30 years ago, 20 years ago. But here's the issue. Lawyers creatively in court, and then courts accepting this, have treated the bankruptcy law a little bit more like an Oprah Winfrey show. You get a liability shield, and you get a liability shield, and you get a liability shield.
Everybody reach under your chair. There's a liability
There's one right
shield for
there.
you. Uh-huh.
Bankruptcy gives that protection to the debtor, the company that files for bankruptcy. There are supposed to be a lot of checks and balances, and that's the end of the road if they make it all the way through the system in a Chapter 11.
Okay, so
The
Purdue Pharma files for bankruptcy, and you say it has this problem about figuring out the right amounts to give to people, but you get it. The company filed for bankruptcy, but something else happened in that bankruptcy.
so the deal was most of the money that's put in the pot, primarily for opioid abatement going to the states, the families were getting a very small proportion of that pot. So whenever we hear about the 6 billion, first of all, it's a small amount of all opioid settlements that have gone on, mostly outside of bankruptcy. But most of that money is not going to the families one way or another. But the Sacklers say, we'll put in this money, but there's an exchange here that we want to be protected too, forever, against anyone who has a direct claim against us, says, you, Richard Sackler,
the guy
hurt me.
who ran Purdue and helped develop and market the drug, okay, says it's fine for Purdue, the company, to go into bankruptcy, but Richard Sackler says, I'll put some money into this bankruptcy, but
I want my liability shield forever. I want this to be
treat
like
me like I
Oprah.
filed for bankruptcy.
Treat
right?
me as if I filed for bankruptcy, even though I didn't provide all of my assets here. And some of them are, by the way, in the Isle of Jersey, which I had to look up on a map. I'm not familiar with all
Where
the
is
asset
that?
protection parts of the country.
Yes. Uh-huh.
And on the one hand, I get it. They say, this is it. Here's the money we're going to give. We want to forget about this. Well, putting aside that the families affected by the opioid crisis will never forget about this, not an option for them. It's not in the bankruptcy code. Bankruptcy code is the Bible for the bankruptcy world. And in personal bankruptcy cases, we don't have a lot of, we have a lot of local culture, and different things work differently in different places, but we don't have anything analogous to saying, by the way, I'd like to protect other people as well. And so this is about how broad, for companies usually don't like, or they say they don't like, broad federal powers. They want to sue to invalidate a lot of laws, but bankruptcy, they want more than Congress provided. So the Sacklers say, we want a liability shield, not but for all the Sacklers, for over 1,000 other parties. We don't know who put in what money. We don't know exactly what the relationship is, although maybe some of that was negotiated behind
Right.
closed doors.
And just to remind everyone, what's happening or was happening in the Purdue bankruptcy, that's not the only one that said we'll put the legal entity, the corporation, in bankruptcy, but we want to get relief for everyone else. And think about it this way, right? That Richard Sackler says, look, I have my sacks of money over here, and if you'll give me relief, I'll give you 2 sacks of money. And people say, wow, 2 sacks of money. Of course, I have no idea. He may have 3 sacks. He may have 20 sacks. I don't have any way of knowing because he never filed for bankruptcy. He's not the only one doing that. Do you remember any of you talk about it in your book, some of the other cases where someone who's not in bankruptcy is still trying to get all of that bankruptcy protection under the Chapter 11 Swiss Army knife theory of bankruptcy?
Oh, yes. So, and I do want to make clear that the Purdue and the Sacklers were no trailblazers here. They pushed the boundaries more with given the size and activity of all the state attorneys general. That put a different spin on things, but we of course started with asbestos. And let me say, for the early asbestos cases, they were not protecting parties who were accused of independent wrongdoing. They were channeling money away from insurance proceeds and
companies.
things like
Yep.
that.
Yep.
So
Yep.
it's very different. We use fancy words like derivative liability and direct liability in law, but let's just think of, why would somebody sue me? Did I do something wrong? And so
Right.
Richard Sackler is alleged to have done something wrong. Michael
So the boy,
Milken.
yeah, go ahead. Yes.
Michael Milken was alleged of doing something wrong when his investment bank imploded after that vast allegations of securities fraud. A.H. Robbins, women around the world who were sold aggressively marketed birth control that led some of them to not be able to bear to have children at all. Some of them died. And it also didn't work as birth control either.
Yeah.
That was really, I think, the H. Robbins case is the most analogous to me to the Sacklers, because the Robbins family was accused of their own wrongdoing.
Right.
And
Right.
they got a shield.
Right. Boy Scouts of America is involved.
Boy Scouts is, well, yes. So Boy Scouts is a very interesting example and parallel in that the Boy Scouts, the National Boy Scouts organization, does not have that many resources, relatively speaking. The money is in the local councils, the assets in the local councils. And the deal was to protect Everyone. Now that case is already all the way through. I know that there's some who want to reopen it. I think it's going to be too late for that. There's already survivors are already being paid. I
Right.
think that it's already done.
Catholic,
It's in the past.
right, Catholic Archdiocese
So
at least
over
raised the
35
issue.
Catholic dioceses for 20 years, and the number is going up of dioceses who seek to deal only with adults finally getting to reckon with child sex abuse and the church alleged cover-ups.
Right.
And here's where I just want to mention the states' rights element here, because we have legislatures around the country who are saying, we want to give our residents a day in court. And they're
Yeah.
opening up the law to say, even if it happened a long time ago, we want you to have the chance to tell your story, to ask for documents like you can do in a lawsuit. And the dioceses are filing for bankruptcy in direct response to states trying to give more justice to their residents. And we know that that's a Sackler-related issue because
Right.
the United Conference of Catholic Bishops filed a brief in support of the Sacklers in the Supreme Court saying, we really need you to give the Sacklers that protection because we need that protection in our own bankruptcies.
So you've laid out the problem and you discuss it and you explain it so well in the book. And then the United States Supreme Court just stepped up in the Purdue bankruptcy case. Tell me what you think about this. Talk a little about the decision there.
The decision looked at the bankruptcy law and said, there's no authorization here for the Oprah approach. Congress did not authorize the Sacklers to get a liability shield without filing bankruptcy themselves. The majority, it was just 5, a bare 5, that said, it's not in the law, so you can't do it. I was shocked the Supreme Court took this case. I was shocked they took it on a very expedited basis. And then they sat on it for months and months and months. Of course, they had other things to do. So the longer this went on, the less sure I was about what was going to happen. I thought they were going to find a way to maybe punt and say, we're not really going to decide this. But they did reinforce the boundaries of the bankruptcy power. It's an extraordinary tool. And lawyers who work in the field might get very accustomed to thinking, well, makes the best of a bad situation. We don't think their claims are worth that much anyway. That's not how it works.
Okay, so
It's a powerful tool, limited.
So the Supreme Court has broken off at least one of the, the corkscrew off the Swiss Army knife.
Almost.
Almost. Why do you say almost?
Well, I don't want to get too in the weeds, but consent is a big issue here. So let's go back to the families that did want to make the deal with the Sacklers. And in the book, I'm trying to listen to what a range of families say they want. It's not for me to say what's in their best interest. I'm trying to listen to them. So some families say, I am willing to release the Sacklers, and they're allowed to do that. They're allowed to do that without bankruptcy. That is their right. That is their autonomy. The question is whether they can bind everyone else when it's not the debtor. So the court is basically talking about forcing people to accept that they can't pursue the Sacklers anymore, but it expressly doesn't answer what counts as consent. So how do we know if a family agrees or not? Is it if they say nothing, is that consent? If they check a box opting out, is it consent? Or do they do what I think multiple people in this conversation thought was necessary, which is to affirmatively sign something that says, yes, I understand that I can't sue Richard Sackler anymore, to make it that affirmative. They didn't say. So I think right now, people around the country working on these cases are thinking about the opt-out, thinking about that box on a very long document. So I have to say, I think it was a very important step forward, but we're going to have to watch how courts deal with that.
So not finished yet. That's a very interesting point about what happens next in this. So let me ask you another question coming out of this. When you've got the court kind of saying, whoa, Go back and read the statute. I mean, like, it's not in there for Richard Sackler to say, here's 2 bags of money, and therefore everybody has to go along with the deal I've worked out with some of you. What's going to change following this Purdue decision, and what's likely to stay the same? And I particularly was thinking about, you talk about the Texas two-step in both your New York Times op-ed and in the book. Another strategy used by big companies in bankruptcy, in effect, I would describe it as they take a big company and it's got this terrible thing they did that they put out, and they divide the company into 2 parts, one with all the assets and good business going forward, and one to hold all the liability. And then they put the one with all the liability in bankruptcy and protect all those assets everywhere else. Will the Purdue decision, do you think it will have any impact on moves like that?
I do think it will have an effect, but people are going to argue otherwise. But
Fair enough.
here's the thing. So first of all, this move of saying, let's take allegations we did something really bad 10 years ago and put them in a new company and put that into bankruptcy. You could do that with any kind of liability. We saw something like that in the Corizon case in Texas, dealing with prison health care. Operated a little bit differently, but it still had that pattern. So for those cases, absolutely, it has an effect, because it means that you can't do the Oprah. You can't give everybody a liability shield unless people are asked their opinion about whether they consent to that or not. The reason I hesitate on the other category is that we're hearing a lot of those cases are about asbestos, and even Johnson & Johnson, which says, oh, our baby powder never contained asbestos. They consider their own repeated efforts to use bankruptcy in asbestos case. Asbestos has a little bit of protection, more than a little bit of protection for third parties. It channels the claims of injured people to a trust so that the insurance company and other related parties can't be sued. But I don't read that language as going to allegations of independent liability of third parties. That was all simply because you just happen to be related to the debtor. So as far as I am concerned, and I don't think I'm the only one who sees it this way, even if it's an asbestos case, all of those cases are made more vulnerable by the Purdue decision, because in all of those cases, it can't be the debtor that's the primary tortfeasor. They just were created yesterday, and the problems are old. So I think they do have this issue that it's another problem with the Texas two-step. Those cases are already very slow. Of course, the companies don't care. In the meantime, they've blocked jury trials for years. But in terms of if they're really serious about getting over the finish line and protecting the entire corporate enterprise, I don't see how that's possible. They can do it with respect to parties who consent to the deal, but not with parties who say, I object, I opt out, I will not accept this result.
Okay, so let me ask you one more question about these big corporate bankruptcies. Why can't we just count on bankruptcy judges to do a better job of reading the law and just say, folks, just narrow yourself down to your job. Read what the statute says and don't go beyond it. If bankruptcy judges didn't enable the development of all those extra, the screwdriver and the Phillips head screwdriver and all those things on the Swiss Army knife. I love that metaphor, obviously. If the bankruptcy judges wouldn't permit it, this whole thing would be cut off at its root. Why doesn't that work?
For quite a few reasons. For first, when allocating responsibility for these problems, I'm mostly trying to look at the bigger structural factors, which means that leads me to look at the Supreme Court, appellate courts who have enabled this kind of activity for years, decades indeed, in part because they've been overly pragmatic about it. So I attribute a lot of the responsibility to circuit courts who had many opportunities to say that's not what the law says. And over again, they said otherwise, at least a subset of courts. Here's the other problems. First of all, corporations in America can file bankruptcy wherever they want.
Mm,
There is no meaningful constraints on where they can file.
right.
So
They do business everywhere. Yeah.
even if 99% of the judges said we only follow what the bankruptcy court says. And again, remember that the circuits who they have to follow have already authorized this. In quite a few circuits have said this is possible. So they can't only look at the bankruptcy code and do that. Someone else will. Someone else will do it.
Mhm.
And even if it weren't in America, it could be in Canada, it could be in Singapore, it could be in the United Kingdom. International forum shopping going on right now. But I also want to say that there's a reason that this book is not geared toward bankruptcy judges and just wagging my finger at them saying, try harder.
Mhm.
I think I am a huge fan of the bankruptcy bench. I do think overall they do the best they can with the really difficult constraints. They hear every day in business cases, for those who have large business cases, most of them don't. If we don't do it this way, everyone will get fired, nobody will get anything, and implicitly, your name is going to be in the story that said this all fell apart. I think the
Mhm.
pressure on individual judges is enormous to try to use bankruptcy as a problem-solving place.
Right. That's a
Um,
nice point, especially when people come in and say, I have solved the problem.
we did
All
it
I need for
behind,
you to
yes.
do is do the blessing over it. And if you'll
Well,
just
that's
bless
right.
the problem, we're done.
And
Yeah.
Congress did invite that approach to it in trying to say there is some discretion in the bankruptcy code. It can't possibly be as broad as the dissent in the Purdue Pharma Supreme Court case thought it was, but there's some. Congress also said we don't want bankruptcy judges going into the back rooms, in the conference rooms, and being part of these negotiations. So they don't have a lot of the facts. They're not, and they have what's put before them. And so much of what they might be able to use to push back has already been taken off the table. For
Mhm.
example, in the Boy Scouts, the predictions of how much money you would need to compensate survivors of child sex abuse varied tenfold between the experts. They negotiated, they negotiated, they negotiated. By the time the committee representing survivors signed on to a plan, they agreed. We're going to shelve our proposal, our expert. No one's going to see that. The judge is only going to see the one that says everybody's getting 100%. And the Boy Scouts have continued to say that. They said it to the Supreme Court in two separate
With,
briefs
with a straight face.
with a
Mhm.
straight face, while their trust, separate entity, and a very respected retired judge who's reading the fine print and looking at the documents, looking at the finances, is telling the survivors, you're not you're not going to get 100%. It's very unlikely you'll get that. And right now you're getting 1.5%. And so I say that because I don't consider that something the bankruptcy judge could have solved themselves.
Fair enough.
Um,
Fair
it is
enough.
an adversarial process. That information was taken off the table.
Okay. So that's kind of a big part. There are more examples on the corporate side. I urge everyone, read the book. It is enormously readable, the way you describe what were often quite benign, quite well-intentioned portions of the bankruptcy code that a combination of smart lawyers and circuit court judges who never said no have created now problems that have now infused the system. I want to make sure before we go to the audience's questions that we talk about that other half of bankruptcy where we started, and that is you talk in the book about how for the average American, the bankruptcy process has become more costly, more difficult to navigate. And you specifically, and we know that is true when the new provisions were added to the code, but specifically you say the current system exacerbates racial inequality. Can you say a little more about why and how that happens?
So there's a variety of studies that have been done over really now 20 years, although I think there was some suspicion of the problems even earlier, that shows that Black families pay more for bankruptcy relief and get less protection.
Yeah.
And it comes about through a variety of paths. And that's always the problem. There's not one magic thing. There's not one provision of the bankruptcy code that we could just cross out and make it go away. So one big part of the problem is the complexity of bankruptcy involves having two separate types of personal bankruptcy. And African American families are disproportionately steered into the more expensive kind where less relief, they receive less relief. Everyone receives less relief in that chapter, but even on top of that, African American families receive even less relief.
Mhm.
We add to that the the debts that cannot be canceled, fees and fines for overgrown lawn or jaywalking or a driver's license suspension for a parking ticket, are disproportionately affect African American communities, and those are the ones that have been singled out first by Congress, but then even more by the Supreme Court to say you can never get rid of those. On the asset side, bankruptcy filers can keep some stuff, not a lot of stuff, but some stuff. The assets they can keep, the property they can keep, is what Michelle Dickerson, a wonderful professor at the University of Texas, says is optimized for white families.
Mhm.
So even though some suggested that exemptions, if someone's allowed to keep a certain amount of stuff, we shouldn't care what it is. We should let them keep whatever that minimum amount. Congress has always said, no, we have to prescribe what you can keep. And because of existing racial inequities, uh, there are real differences in how the very limited amount of assets that African American families have.
So
So it's a
you're
combination.
so you're hitting on this deeply moralistic element of personal bankruptcy, not only in the underlying assumption that people who file for bankruptcy are probably trying to cheat everyone else, deeply moralistic. So let's examine them. Do we examine, I love the way you keep making the comparisons. Do we examine whether or not a giant Chapter 11, giant company goes into Chapter 11? No. But we really scrutinize the families that file for bankruptcy. We make them engage in upfront costs and disgorge all kinds of personal information. But that the system is even optimized in a way that exacerbates racial inequality in this country. And I think it's one of the way you put these arguments together is really powerful because, as you rightly point out, it's lots of ways it happens, but it's when you see them all together that you realize just how strong it is. Let me ask one more topic related to this, and that is student loan debt. Um, why is that debt treated differently than so many other kinds of? You go to the mall and run up a bunch of credit card debts. You know, you buy a bunch of just stuff. No problem discharging it in bankruptcy, but not so for student loans. Why is that, Melissa?
Well, student loans have been a political and legislative football for decades at this point. And once upon a time, you were able to cancel some student loans if you had been trying to pay them for a certain amount of years and then could say, I can't do it anymore. Look at my financial situation. Over time, even though this argument has been made about why why should you discourage people from taking on student loans, we want to give people an incentive to try to better themselves, get more education, try to start a business, and then maybe it doesn't work out. It's been chipped away piece by piece, and then special interests piled on to say, hey, I give student loans. They're not that government guaranteed kind. They're not that reasonably priced kind,
Mhm.
but we want to get in on this too. So once upon a time, the argument was we're protecting the government fisc, that we need to preserve the money for student loans so that we can lend more of it out. I think probably your your teams have showed how that's not at all how it works, but it certainly doesn't work that way for private student loans.
Yeah.
So it was incremental to make it so hard. But the story that I tell in Unjust Debts about a woman who's actually profiled in the newspaper, who, if there was ever a case to be able to be allowed to cancel student loans under this undue hardship standard, again, that sounds discretionary, that courts are supposed to be able to grant relief when someone appears worthy. Um, she couldn't. She's stuck with them forever, even though she's very ill, has applied for jobs and can't find ones that she can do with her illness. And that's because it isn't even, and again, it's not the bankruptcy judge here. He's following the Fifth Circuit Court of Appeals, who's become pretty famous in recent times for lots of rulings on lots of things. But by saying you basically have to be hopeless, no possibility of ever having a bright spark in your life to fit this exception.
So, it's a really interesting contrast that you give us here, Melissa. And that is how the circuit courts on the big corporate side have basically said, have at it, whatever the giant corporation wants to do in order to restructure their debts, 2 thumbs up. But when we're talking about live human beings who are sick, who have hit terrible times, and who need a little debt relief, for example, on student loans, but it happens in other areas, the circuit courts take what is deliberately expansive language in the code, lots of judgment for the judge, and said, we don't want bankruptcy judges using their judgment here. We want a hard and fast rule that says, if there's any chance ever, this person is going to earn a nickel, no discharge on these loans. Yeah, real difference here. Echoed in
Yeah, and
that.
one reason I wrote this book and wrote it for the public and tried to tell stories to make it accessible is so many people who study or work in the system do one kind of case.
Yeah.
And so they don't see across. They get used to the kind of case. They
Mhm.
only do big cases. That's all they see. They only study big cases. So they're only looking at that universe. Once you look across the whole sweep, it just opens up so many more questions about why is it this way? It doesn't, there's not a right left issue even. It doesn't make sense.
Right.
So
I have to say, one of the things I love best about this book is the fact that you keep drawing contrasts that just don't otherwise show up. And they're the kind of contrasts I found as I read it that I'd say, oh, right. Why are we doing that? I get why we do one, I get why we do the other. And then when you see the two together, you say, this is wrong. And often it's exactly backwards. The ones who should have maybe a little more flex in the system should be families down on their luck, individuals. So that gets me through most of my questions. I have at least, another 1,000, but I thought what we'd do is we'd turn to questions from the audience via the YouTube chat. So I want you, I love it. First question we've got here. You ready for this one, Melissa? Can you talk about your time as a student in Senator Warren's class? Evidently, we got this question multiple times. Are there any takeaways or things you learned that you incorporate now in how you teach law?
I'm just going to start, but not finish with an inside joke, which is
Okay.
that I know now what assumpsit means. So, and I have a feeling that the
Mhm.
asker of that question, who may or may not be also having a birthday today,
Mhm.
could have been thinking about that. I learned your teaching did influence me quite a bit. And I think it shows in the book as well that you made all voices in the classroom relevant. And people don't always, they call it cold calling still in law school, to say calling on people who don't have their hand up the whole time. And my view is if you only call on the people that have their hand up the whole time, that is cutting off a whole lot of learning and engagement. And so I learned that most from you. of any of my professors in law school, and it's been a really important tool that I have carried forward.
Oh, that makes me feel good. I'm glad that you're careful about that, Melissa. It's really important.
I really am.
So
I try.
Next question. What's the biggest myth or misconception about bankruptcy?
Ooh. Well, the old chestnut would be that people who file for bankruptcy are just running up their bills, not being careful, and think it's super easy to go drive by the bankruptcy court and get some relief, and that they don't care about the consequences for anybody else. So that's one. I think that is not the vision that comes from decades of systematic study of the people in bankruptcy. So that one's not true. Another one I think is that, well, if we put everyone in what's wrong with putting everyone in a payment plan? That isn't that going to make creditors better off and give everybody more access to credit and the like? That's sort of the economic argument. And what I've seen is that it takes a lot of bureaucracy to try to collect dollars from people who have almost nothing. And so much of the money in payment plans for individuals they go to lawyers, they go to a trustee who's hired to oversee the system.
Mhm.
And well, that takes a whole lot of it. And then they go to creditors who would have had to be paid anyway, a car loan, a mortgage, very little for the claimants who were
Child
supposed to be the
support.
ones to get it.
Mhm,
Well,
mhm.
yes, absolutely, child support. So I think we do need to break away from the idea of that what sounds good in theory works out on paper. And I would say the same on the Chapter 11 side. I hear a lot, including from academics who like to think about the theory. What's wrong with setting up a big trust to pay claimants? And I say, why don't you come with me and look at what's actually happening? Where is the money going? Is it following through with what's promised?
Mhm.
So I think
Yeah.
buying too much into the theory and the myths, just to circle back to the question, and
Right.
not enough into how things look on the ground, which I also learned from you, Senator
Yeah.
Warren.
Well, but you know, what you're talking about here is structural and how the repeat players are the ones who actually turn out to make a handsome living out of a process that is mostly about not enough to go around. And I think that's a very insightful point you make. So the next question is a really good one, and it was actually on my list too. If you had the magic wand and you could change only one thing about the current bankruptcy law, what would it be and why?
I would change personal bankruptcy. I would prioritize that because I think it is the most important part of the system. And it's the part that is really not coming through. We know Bob Lawless has estimated that 1 out of 10 every living Americans has been through bankruptcy at least
Yeah.
once. And that's at a time where bankruptcies have been hit historic lows recently. They're going to go up. The system needs to be more effective, but it also, the racial disparities, we can't just lament them and have another day. Something must be done. So I think we have to move to a one chapter to merge these two chapters and have a single chapter bankruptcy system. Economists have proposed similar ideas about a very simple model for the vast majority of people to go through. But that's where I would prioritize. And I want to believe that that could get bipartisan support.
Yes. So the next question is an interesting one. When a board of directors acts with gross negligence, why are they not sent to prison? Why are they protected by bankruptcy law? The person here asks, why is it okay to injure an investor?
I'm going to recommend a different book by Jen Taub called Big Dirty Money that talks
Uh-huh.
about a lot of those issues. I do want to clarify that for bankruptcy addresses civil liability. It is not supposed to address criminal liability. It is not supposed to make the difference whether people go to jail. Now, I hear a lot from people involved in the Purdue Pharma case or grieving families that they still are looking for justice on the criminal side of uh, for the Sackler family. And I would be remiss if I didn't mention that. In terms of investors, I think we're back to the same issue that there's only so far bankruptcy can go. If someone willfully and maliciously injures someone, if someone commits fraud and they're an individual, bankruptcy does not clear them of those obligations.
Mhm.
And I support those exceptions to discharge. I think they should also apply to fake people as well, or at least I think we need to examine that distinction more closely. So there is some effort, especially when we're talking about humans. There are things that cannot be canceled in bankruptcy when someone is engaged in that level of wrongdoing. But that doesn't answer it can't answer the question of why people are incarcerated for those kinds of alleged crimes or not, because that's a different part of the legal system.
Yeah, I I think there's a really interesting question that underlies. You do so much of this good comparison in your book, but it's this fundamental question of what do we value and how much do we value it? Because if you read everything outside bankruptcy, you read contract law and you say, oh, I see, we value honoring your promises. And if you read law of families and child, we value protecting access to child support, for example. Tort law, we value at least money compensation for people who've been physically injured, right? You and I could go through the list. And if you only read the list outside bankruptcy, you could have a big, long list of things that says we value all these things. And all it would tell you is we value them. We acknowledge them in law, and we say if you go to court, you can collect money for it. Parentheses, if the person who did it has money, the fake or real person. And then the if gets played out in bankruptcy. And in bankruptcy, you start to read this entirely different list of it is so damned important that you repay that student loan debt, that even if it means you've got nothing, you are living in poverty, you cannot afford the rent on an apartment, and you got to live in your mom's basement forever. Too bad. We prioritize the importance of paying those dollars back, squeezing the last nickel out of you. But if you are a giant corporation, if you are Richard Sackler, and you've offered a couple of bags of money, and a lot of people are willing to go along, all of a sudden, we care a whole lot less about what the original promise had been to the surviving moms and dads of everybody who lost a child to the opioid crisis.
Yeah, I think that, and I would just add two things to that to say, one bigger picture frame I try to put in the book is that it does go beyond bankruptcy in that so much of our legal system says the remedy is money. And then once the remedy is money, everything becomes a little bit fungible, even if there's a world of other possibilities that needs to be imagined. But it makes it a lot easier to say it's all just dollars and cents. The other thing is that when we go into Chapter 11, I think if we were to look back and at the time Chapter 11 in 1978 was being revamped, there were a lot of questions unanswered about environmental law versus bankruptcy, healthcare versus bankruptcy, employment discrimination versus bankruptcy. It wasn't supposed to be that bankruptcy trumps all. It was supposed to be every statute has to have a balance of considerations. Other laws still apply. So when people have taken the message enhance economic value, maximize economic value over and over again, first, it's often not even proven to be true. It's hard to prove that it does maximize value. The second is, do we want to live in a society where the Constitution doesn't matter, where the other laws don't matter, but an expert says that all we care about is maximizing economic value? That is scary to me.
You know, I want to wrap this up, but it's got one more little twist on it, and that is who pays when somebody goes bankrupt? Because that's at the heart of this as well, both on the corporate side and the debtor side. You want to use this as your closing remarks because it very much fits into the theme of this book.
Well, there's a narrow question of who pays and then the bigger question of who pays. So I want to put in a pitch for even the narrower point, which is bankruptcy is a system where you have to pay not to pay. And that on a bipartisan basis, the idea was no expense to the public, or often taxpayer is the way it would be stated, to say we put the costs on the individual or entity who's filing for bankruptcy, as well as the creditors who want to participate in the case. They have to pay to file stuff too.
Yeah.
And
some people are too poor to file for bankruptcy.
They absolutely are.
Uh-huh.
And on the business side, it has distorted things a lot. A type of bankruptcy we didn't have time to talk about are the ones, these really quick sales of companies. And that's because they're being financed only by a lender, a private lender, who understandably has no obligation to anyone else except themselves, who says, well, I'm going to pick apart the bankruptcy law and I'm going to pick and choose what I want. And they can do that because they're funding the case. So I think if we want a fairer bankruptcy law, we have to rethink the financial plumbing of our bankruptcy system. If it's going to be a safety valve that balances considerations, we can't make it this kind of privately funded. In the bigger picture of who pays, I think there is too much short vision that's going on here about, well, if someone's allowed to get relief from their debts, someone else is going to pay more at the gas pump or the like on the business side. But I think the costs are much greater because we are talking about, these cases implicate gun violence, climate change, inequality, the list goes on. And we're not able to measure that a case at a time. And so everybody needs to think about bankruptcy as a part of the legal system. I think it should shrink and be less of a part of the legal system so that we don't have to ask as many of those questions. But in the meantime, everybody needs to be paying attention because the costs are not just in dollars and cents.
Well said, well said. So our thanks to Professor Melissa Jacoby, author of Unjust Debts: How Our Bankruptcy System Makes America More Unequal. I encourage everyone to pick up a copy of Unjust Debts. You can get it at your local bookstore. If you'd like to watch more programs or support the Commonwealth Club's efforts in making virtual and in-person programming, please visit commonwealthclub.org/events. I'm Elizabeth Warren, here with Melissa Jacoby. Thank you for joining us, and take care.